Hello everyone, this is Dr. Sheetal Babar. In this session, we shall be discussing provisions of will and codicil under Indian Succession Act. Now, under this session, we shall be answering few questions. Instead of going through the sections and instead of going through the detailing, we shall be more discussing about the concepts and understanding of this provision of wills. Chapter 2 of Indian Succession Act deals up with all of the provisions concerning to wills and codicils. However, will has been defined under first chapter definitions. Now we shall be raising few questions and shall be answering those to understand these provisions of will. First question is what is a will, and we shall be defining will as per Indian Succession Act. Secondly, who can make a will or who are those people who can execute a will shall be the second question raised, and answer shall be section 59 of Indian Succession Act, and so on. Next question is what are kinds of will, for which we shall be discussing section 63 and section 66 in January. Next, how a will can be executed. Are there any rules to write a will? Is there any language to write a will? Is there any essential for executing a will shall be answered. And lastly, we shall be dealing up with what are the provisions concerning to revocation of a will. That means, is a will revocable? Can it be revoked? And if yes, on what basis or at what instances it can be revoked. So let us start up with our first question, what is a will? So let us see what is a will. Section 2, subclause H of Indian Succession Act defines will. It states will means the legal declaration of the intention of a testator with respect to his property which he desires to be carried into effect after his death. Now when we read this definition of a will, there are certain terms which we can claim as characteristics for a will. The very first is there needs to be a testator. Who is this testator? The one who wants to write a testimony for devolution of his property after his death. So it's a testament. It's something in written or in oral maybe, which that particular person wants to devolve after his death. So there needs to be a testator is the first characteristic. Secondly, he needs to have intention. So there needs to be an intention of this testator. Intention to devolve his property after his death is must. Or testimony, intention to write down or to have this testimony for the provision of devolution of his property after his or her death is something which is an essential characteristic. Thirdly, there has to be a legal declaration. So intention just need not be mere intention, but intention of the testator should be to have a legal declaration. That means to give that legal effect to his piece of paper on which he might have written or she might have written the provisions or written the shares of particular people or rules or provisions of devolution of his or her property. So third is legal declaration. Fourthly, this legal declaration as an intention of the testator should be concerned to his or her property. Now, when we mean to say his or her own property, that means the property which is owned or do have absolute ownership of his or her. So there has to be a legal right to have a legal declaration. Though intended sometimes if the property is not of the testator, he cannot while living or he cannot make any provisions after his death also concerning to the property which is not his or her. So these are the characteristics which we say. The fourth one is property. There is also desire. So intention is not the only one word which is used under this definition, but desire to give effect to these provisions after his death. So he desires, his intention as well as desire to devolve his property after his death, or her intention and desire to give effect to whatever she has written or made the provisions for, to get devolve the property as per those is must. And finally, the effect of which has to be after the death. So, fifthly, death is the incidence, one of the characteristics for a will to be a valid will. So, these are 5 characteristics we derive from the definition. First, there needs to be a testator. Second, there needs to be a property. Third, there needs to be an intention for devolution of this property. And fourth, there should not be just an intention but a desire to give this effect after the death. And finally, the instance of the death must happen for actually executing or implementing this will. So this is basically what a will is. Now let us go ahead with the second question, that what are kinds of will under Indian Succession Act. So section 63 and section 66 gives us an idea that there are 2 kinds of wills. One is unprivileged will and second is privileged will. Section 63 gives us not actually the definition of unprivileged will, but it talks about the general will which is we consider as an unprivileged will. And why is this unprivileged will? Because this is something which can be made by any layman, any general person under no apprehension of death. Hence, unprivileged will do have certain specific rules for its execution, wherein these rules are definitely not applicable for the privileged will. Section 66 gives us an idea as to what is privileged will. It talks about certain category of people, a soldier, an airman, as well as a mariner. These are 3 category of people in certain circumstances making a will which can be considered as a privileged will. So let us first discuss as to what is unprivileged will, because it is something which is applicable to all of us, or which we make applicable usually in our practice. So unprivileged will as per section 63 gives a certain rule as to how unprivileged will is executed. It states, every testator, not being a soldier employed in an expedition or engaged in an actual warfare, or an airman so employed or engaged, or a mariner at sea, shall execute his will according to the following rules. So see, in the very text of section 63, there are certain norms which we can derive as unprivileged will. It states every testator and gives a condition who can be this testator under section 63. All of the persons except those who are soldiers, who are airmen, and who are mariners. These are exceptions. These are people who cannot be considered under section 63 because they are considered under section 66 as privileged people. So every individual except these 3 categories can make a will with certain rules, and there are 3 basic rules to execute a will. Which will? Unprivileged will. So let us see what are these criteria, or how, by which accord these execution of the will has to be done. The very first rule states the testator shall sign or affix his mark or signature of person signing for him. So, to execute a will which is unprivileged will, firstly, it has to be signed. Not necessarily signed means he has to put his signature. He can just put a mark. Say, for example, a thumb mark. can be an affixed mark, which is mentioned under Rule 1, Clause A of Section 63, or signature of the person signing for him. So not necessarily always the testator himself has to sign the will. He can make it signed by someone else also. Say for example, I am medically ill, I am paralyzed and I want to make a will. I'm not able to put my signatures also, as well as I cannot put any mark. Either to put my mark, I have to make someone else to put my mark. Instead, I ask some another person who is eligible to do so to put his signature as for. So he shall be representing himself on behalf of me. So that is how the first rule talks about. However, this person who signs for some another person should sign in front of the testator. So presence of testator while someone else is to be made representative or is to be made to sign the will has to be present in front of each other. Second rule, clause B states the signature or mark of the testator or signature of the person signing for him shall be so placed that it shall appear that it was intended thereby to give effect to the writing as a will. So there should be no suspicion, because will is something which shall be executed only after death of the testator. So every single thing should be looked into meticulously. One of that meticulous thing is the signature need to be put immediately, for example, after the completion of writing of a will. It doesn't give us a suspicion. There is no space left in between the signature and the will or the wordings of the will. Where does the suspicion come up? When I have intended to make a will, but I have put my signatures, say after at the last of the paper, and my will gets over in first two lines of that paper. This gives a suspicion. Why this much of space? Just an example, just an exemplary thing. So there is a rule for execution of a will. Clause B of section 63 lays down this rule. It states that signature of the person signing the testator or the person who is signing for the testator needs to be placed in such place on the piece of paper where the will ends, so that the intention is quite clear and it does not appear anything as a suspicion, or it does not create any doubt in any person who is a layman and not an expert. Third rule gives us a criteria that this will shall be attested by two or more witnesses. So there needs to be two or more witnesses. So minimum criteria is given here that there needs to be at least two witnesses attesting this will. Now, the criteria for these two witnesses is each of whom has seen the testator signing or affixing his mark on the will. So now there again is one more criteria for execution of a will. The first is the testator should put his signature or affix his mark. He can make someone else to put his signature on his behalf. Secondly, he can put that signature in such a place that clear intention has been displayed. And thirdly, this will needs two minimum and many witnesses which need to put their signatures only when they see the testator signing that particular document. So this is how we say the basic execution rule of the will, which is unprivileged will, is all about. Let us talk about what is this privileged will. Privileged will is discussed under section 66 and so on. 66 gives us an idea what is privileged will, and 67 gives 65 gives us an idea what is a privileged will, and 66 gives us a mode of execution of this will. So what does 65 state? 65 gives us an idea of the criteria of people who can be counted under this privileged will concept. We've already discussed this earlier. There are three criteria of persons. First is the soldier. Second is the airman. And third is the mariner. Three of these category of persons are considered to be eligible to make this privileged will. However, there is one more condition under section 65. It states these three category of persons only if they are engaged in actual warfare. So either they are under the expedition of the actual warfare or they are actually engaged in this warfare. That means the very intention of the legislation is that the person who is under apprehension of death can make a privileged will. However, the criteria for this is quite clear under section 65. Three category of persons under certain condition, that is engaged in actual warfare or in expedition. These are the criteria for privileged will. Now let us see what modes are concerned under section 66 to execute this privileged will. The very first criteria or very first rule is this privileged will not necessarily be written. It can be oral. However, it can be written under the hands of the testator himself, or he can make someone else write it up. It can partly be written by himself, or he can make it partly written by someone else. If it is written by someone else, there is no need for attestation. So no witnesses are needed when it is written by someone else, because it is considered that someone else who is writing this up himself is a witness. Next is, if it appears on the face of the instrument that execution of it in manner intended by the testator was not complete, the instrument shall not by reason of that circumstance be invalid. So, under this apprehension of death, even if the testator wants it to be written, but that could not be possible because of the circumstances, and he just specified certain properties to be devolved onto certain persons, though he intended this to be written by someone else but could not be penned down due to the circumstances, need not necessarily be considered as invalid will. This will be considered as a valid will only after death of that privileged category of person. Because we've already seen what are the characteristics. One of the characteristics is the will can be executed only after death of the testator. So this is what our answer for what are kinds of will. Now let us go into our next question, that is what or who basically can make a will. So what are the conditions for the person or the testator to make a will? Who can make a will? There are two simple conditions given under section 59. Section 59 of Indian Succession Act gives us that a person who wants to make a will, that is a testator, need to be of a sound mind, and secondly, need not be a minor. There are four explanations given under section 59. The first explanation talk about a married woman. There might be a condition where a married woman before her marriage has written a will. However, under section 14 of Hindu Succession Act, if it is considered to be a Hindu woman, after her marriage she can make any another provision to dispose of her property, and similarly any another woman who is subject to Indian Succession Act can make any dispositions of her property even after the will during her lifetime. That is the very first explanation. Second explanation is due to certain disabilities, certain category of people cannot be incapacitated from making a will. There are three criteria which are explained under second explanation of section 59. Persons who are deaf or dumb or blind. All of these criteria or categories of people are considered to be capacitated under Indian Succession Act to make a will. They cannot be the individuals or they cannot be the testators who are incapacitated because of their disability. Thirdly, third explanation talks about a person who is ordinarily insane can make a will when internally he is all fine with his mental soundness. So say for example, I am an epileptic patient. There are certain situations wherein I suffer from epileptic attacks, insanity attacks. In all other times, I'm quite sane. In those quite sane situations, I am capacitated or I am an eligible person or eligible testator to make provisions of my property to be disposed of after my death. And fourthly, no person can make a will while he is in such a state of mind, whether arising from intoxication or from illness or from any another cause, that he does not know what he is doing. So simple that soundness of mind is something which is an essential, and soundness of mind is extended to mental illness, intoxication, or any another causes. So explanation 4 gives us certain criteria of which go beyond insanity. It talks about mental illness, it talks about intoxication, and it talks about any other conditions wherein I don't know what am I doing. So it can be under influence of something. It can be under influence of some substance, some individual, or any another conditions or situations. So this is what the basic answer for who can make a will. Now our next question is, what are valid wills? Or where do we consider and how do we consider a will to be valid? So under section 63, there are certain execution rules, and under section 66, there are certain modes of execution for privileged will. While all of these conditions are accorded with, we say a will is valid. And lastly, is there any provision of revocation of a will? Can a will be revoked? Is the will revocable? The answer for this under Indian Succession Act is quite simple. Section 70 of Indian Succession Act specifies how the unprivileged will to be revoked. It gives us three simple and general norms, general rules, how the will can be revoked, or what are those conditions wherein a will gets revoked. The very first condition is marriage. Now, what should be the intention of the legislature to take marriage as one of the conditions for revocation of a will? The reason is post marriage, let this be a male or a female, there is entry of some another male or a female wherein there might be some personal laws which make these people as sharers in the property. And hence, the will made before the marriage except a women, because women post marriage, pre marriage remains an absolute owner, and there is no limited estate when it comes to her own stridhan. So, for an unprivileged will, it is revoked on the occasion or instance of marriage because there are additions to or additions of certain criteria or categories of people in the life of the testator. Say, for example, a wife, son, daughter, and many more. And they in future may be the sharers under personal laws or many a times under Indian Succession Act as well. So marriage becomes one of the instances for revocation of a will. Second criteria is by another will, the earlier will automatically gets revoked. The reason is intention and desire, present intention or latest intention and desire of the testator. So I might feel at the age of 19 that I should dispose of my properties all in the name of the trust. At the age of 29, I got married. Now I have a family. And now I think about the family and the priorities and my responsibilities. And hence I think now, the latest one, that 50% of my property shall go to a trust and 50% of my property shall remain with so and so people, ABC, for example. So, amongst these two, which will to be considered as the one which is the present or the legal document and which to be considered as revoked? The earlier one is revoked will by the recent legal declaration of mine intending my desire to dispose of my property after my death in that certain way. Lastly, third criteria is by some writing or declaration of my intention to revoke the will. So at the last moment, I'm on my deathbed and I write with a pen on a piece of paper that let my will be revoked. That simple um, words are sufficient to revoke my will because that is my intention or that writing is my declaration for revocation. However, under section 70, there are certain other criteria which talk about destroying of the will. The will can be revoked by burning, section 70 says. A will can be revoked by tearing, or will can be revoked by otherwise destroying the same by the testator or by person in his presence by his directions. So, by either ways of destruction, the will can be revoked. So, this is all about Indian Succession Act and provisions, main provisions, briefly and precisely about will under Indian Succession Act. Thank you so much.